Chapter 9 Constitutional Law. The Constitution is the highest law in the land. It sets the framework of our national government and is also used by each state as a template for their own constitutions. This chapter is not covering every single aspect of the Constitution, but will give you an overview of the Constitution, where it most impacts our lives and businesses, and we will close this book out with a discussion of the Bill of Rights. The Constitution is often treated like the Bible. Everyone seems to have their own interpretation of its language, and if it's something they like, then they think it's constitutional or in the Constitution. But if it's something they don't like, then they think it's unconstitutional. This is not limited to citizens and politicians, but can be seen in the many split decisions among the Supreme Court. Also, much like with the Bible, despite everyone having an opinion, few people have actually read it. This might be excusable with the Bible at roughly 750,000 words, but the Constitution is a scant 4,543 words and would only take a few minutes to read. You should have done it by now. When trying to understand the Constitution, it's important to consider the historical context of the document, as opposed to trying to interpret it in a vacuum. The nation had won its independence from England after a long and bloody war. Leading up to that war were countless abuses against the American colonists by King George III, Parliament, and the Crown's administrators in the colonies. During and after the war, the nation was governed by the Articles of Confederation. This national charter was in place from 1781. The War of Independence began in 1775 and ended with the Treaty of Paris in 1783, until the ratification of the Constitution in 1789. The Articles of Confederation were notoriously weak, unable to enforce national laws, and more importantly, did a poor job of resolving disagreements between the states. Because of this, in 1787, delegates from the states arrived in Philadelphia to reform the Articles of Confederation with the intention of making a stronger federal government. However, the Articles were discarded, and debate began for a new national charter, which would become our Constitution. These debates were held behind closed doors to ensure free and open debate at a time when political violence was normal. There was a great deal of fear that this new, more powerful government might simply be a resurrection of what the people had just fought a revolution to throw out. To allay some of these fears, Alexander Hamilton, our first Treasury Secretary, founder of the Coast Guard, and General Washington's aide-de-camp who led a charge at Yorktown, John Jay, the first Chief Justice of the Supreme Court, and James Madison, our third president and the most prominent author of the Constitution, drafted a series of essays that were published under pseudonyms with the purpose of explaining the various provisions of the proposed Constitution. While not actual law, these essays, known as the Federalist Papers, are used today by citizens and judges alike to better understand and interpret provisions of the Constitution. Federalism. The Constitution establishes a federalist system. This means that we have a single supreme government, the national government, and then other smaller governments, each uniquely sovereign within their own spheres of influence. Governmental powers come in two different styles: concurrent powers and reserved powers. Concurrent powers are those that both the federal government and the state government have. Examples of this are the powers to tax, make courts, and provide for the general welfare. Most of us pay both federal and state taxes. You can be charged for crimes or sue in either state or federal court. Reserved powers are those powers granted only to either the state or federal government. Reserved federal powers are those things only the federal government can do. Only the federal government can wage war or conduct international relations. We speak as a nation with one voice in this area. It would be chaotic if only some states were involved in wars, and devastating for states to pick sides of wars or international disputes. Only the federal government can coin money and set weights and measures. Interstate commerce would be next to impossible if we lacked a uniform currency. Reserved state powers are those powers that only the state has authority in. If something is a reserved state power, then federal courts, to include the Supreme Court, has no authority to make rulings on it. Reserved state powers are uncommon and very narrowly defined, as the courts have consistently granted encroachment by the federal government into state affairs over the last 2.5 centuries. Some narrow aspects of voting, education, and the creation of local governments remain the sole domain of the state government. We'll discuss this a little more with the 10th Amendment. The branches of government. The first three articles of the Constitution cover the three branches of government. This is the legislative branch, which makes state law, the executive branch, which carries out law, and the judicial branch, which interprets the law. As we've discussed before, there is a lot of overlap, but these are the main duties of each. Each respective article covers the eligibility, appointment, powers, and duties for that branch. Article 1, the legislative branch. Article 1 of the Constitution covers the legislative branch. The duty of the legislative branch is to create law. Our legislative branch, collectively referred to as Congress, is a bicameral or two-house legislature. It consists of the House of Representatives and the Senate. These are based around the British Parliament. The House of Representatives is like England's House of Commons. Representatives are allocated according to the population of each state. The House of Representatives is sometimes referred to as the People's House. The Senate is based on England's House of Lords. Each state receives 2 senators. The idea of Congress is that the House of Representatives is more representative of the nation's majority, whereas the Senate is designed to ensure that the majority cannot oppress the minority, as can be done in a pure democracy. You may recall from the first chapter that Article 1, Section 8 is that laundry list of areas where Congress is allowed to make law. Congress can only make laws where they have been granted the express power to do so in this section. Article 1, Section 8 includes many specific clauses that require closer inspection. Clause 1 is referred to as the General Welfare Clause and includes both the power to tax and the power to spend so long as it's made for the general welfare of the nation. All tax bills must begin with the House of Representatives per Article 1, Section 7. In addition to simply raising revenue, Congress can tax to discourage behaviors they don't like, such as taxes placed on things like tobacco products. They can also tax to encourage behaviors. Taxing gasoline, for example, will encourage the use of electric vehicles. The controversial Affordable Care Act, commonly known as Obamacare, included an individual mandate to purchase health insurance. The court upheld this mandate by framing the purchase as a tax, thereby granting Congress the constitutional authority to pass it. Congress also has the power to spend to meet these needs. While spending for the general welfare seems obvious, this also includes the ability to withhold spending or to spend unevenly between the states. A good example of this can be found in the case of South Dakota versus Dole, 483 U.S. 203, 1987. This case affirmed the federal government's right to attach conditions to receiving funds. South Dakota, among several other states, had a drinking age of 18. Congress passed a law granting highway funds to the several states, but conditioned it upon the changing of their laws to increase the drinking age to 21. Clause 3 of Article 1, Section 8 is known as the Commerce Clause. This is the most broadly interpreted clause in the entire Constitution and has been cited to grant Congress extraordinary powers that many legal and historical scholars agree goes far beyond the intent of the drafters and signers of the Constitution. The plain text of the clause states, to regulate commerce with foreign nations and among the several states and with the Indian tribes. This small clause was extremely important to resolve trade disputes between the states, especially as it related to goods that traveled through the states. The weak national government provided by the Articles of Confederation were unable to resolve these sorts of matters. The primary purpose of the Commerce Clause is to give Congress the authority to facilitate smooth commerce between the states. The court has inferred the inverse of this in what is called the Dormant Commerce Clause. If the Commerce Clause is designed to aid interstate commerce, the court has determined that it also prohibits states from passing legislation that inhibits commerce between the states. The Commerce Clause has been construed by the courts to go beyond simply ensuring smooth commerce between the states to granting Congress the power to pass laws relating to anything that might possibly travel in or affect interstate commerce. In the landmark case of Wickard v. Filburn, 317 U.S. 111, 1942, decided in 1942, the court ruled that a farmer's wheat production could be subject to federal regulation under the Commerce Clause. The farmer argued that his wheat was used on his own farm, did not enter interstate commerce, and therefore could not be regulated using the Commerce Clause. The court disagreed, stating, "But if we assume that the wheat is never marketed, it supplies a need of the man who grew it, which would otherwise be reflected by purchases in the open market. Homegrown wheat, in this sense, competes with wheat in commerce. What this means is that by not engaging in interstate commerce, he was affecting interstate commerce and therefore could be subject to the regulation. Using this logic, the Commerce Clause was used to justify federal statutes for nearly everything until 1995 in the case of U.S. versus Lopez, 514 U.S. 549, 1995. In a narrow 5-4 decision, the court finally struck down a law prohibiting firearm possession within 1,000 feet of a school, stating that it did not affect interstate commerce. The court sought to more narrowly define what the Commerce Clause grants Congress the authority to regulate. They settled on 3 separate areas. First are the channels of interstate commerce. This includes roads, bridges, waterways, airports, and more. Next are the instruments, persons, and goods that might travel in interstate commerce, even if the specific ones following under regulation do not. Lastly, and in what loosely appears to be a confirmation of the holding of Wickard, are those activities that substantially affect or relate to interstate commerce. This again grants Congress broad lawmaking power under the Commerce Clause, as nearly all activity can affect interstate commerce in one way, shape, or another, especially if you consider it in light of the facts of Wickard. A good example of this is the federal prohibition on marijuana, even if it does not travel in interstate commerce. This was upheld in the case of Gonzalez versus Reich, 545 U.S. 1, 2005, decided in 2005. The Commerce Clause granted Congress the power to make laws like this, and as we'll see shortly, the Supremacy Clause ensures that these federal laws are enforced as superior to state law. Clauses 4 through 17 are much more narrowly defined lawmaking powers granted to Congress. This leaves us with Clause 18, the Necessary and Proper Clause, sometimes nicknamed the Elastic Clause. This clause also grants a large amount of authority to Congress. Under this clause, Congress has the authority to pass any law that assists them in carrying out any other thing the government is granted the power to do under the Constitution. This was borne out in the landmark case McCulloch v. Maryland, 17 U.S. 316, 1819. In this case, Congress sought to create a national bank. No such power exists explicitly among the list in Article 1, Section 8. However, the court held that if Congress required a national bank to carry out its other duties, then such a power was implied in the Necessary and Proper Clause. Better put, if a bank is necessary to raise and support armies, as Article 1, Section 8, Clause 12 allows, then a bank would be proper for Congress to create. Article 2, the Executive Branch. Article 2 covers the executive branch. The executive branch is the president, aided by his executive agencies. The president's job is to carry out or execute the laws passed by the legislative branch. The president also serves as the commander-in-chief of the armed forces, excluding the National Guard, which answers to the chief executive of their respective states unless called to federal duty. In addition to these duties, the president signs or vetoes bills passed by Congress and nominates people to head agencies and to sit on the federal courts. Article 3, the Judicial Branch. Article 3 covers the judicial branch. This judicial power is the power to interpret law and to create common law. Article 3 provides for one Supreme Court and such inferior courts as the Congress may from time to time ordain and establish. This includes not only the Supreme Court, but also the circuit and district courts, as well as whatever additional courts Congress might feel are necessary. Article 4. Article 4 primarily addresses the relationship of the states to each other and to the federal government. It talks about how new states may be made and how they must all have a Republican form of government. Republican, with a small r, refers to the fact that we are a republic, which is a representative government, not headed around a monarch. It is not referring to the Republican Party. Article 4 also obliges the federal government to assist states subject to invasion or rebellion. Article 4 includes the full faith and credit clause. What this does is ensures that every state honors public records, licenses, and public acts, such as court judgments, that are made in other states. If a person gets married in Washington, their marriage must be honored in every other state. If a plaintiff is awarded a large monetary judgment or custody of children, the defendant cannot simply move to a different state and then ignore the judgment. There are some exceptions to this policy when state laws in one state deviate substantially from the state where the license or judgment was first rendered. This is why you cannot get a concealed firearms license in Idaho and have it honored in California. The rules are too different. This, too, is what necessitated the case of Obergefell v. Hodges, which ensured marriage equality. Prior to that case, all heterosexual marriage licenses had to be honored in every state, but not same-sex licenses. The reason for this is because every state permitted heterosexual marriage, but not every state had honored same-sex marriage. Every state in the Union allows people to drive, so all driver's licenses are honored. Not every state allows the carrying of concealed weapon, so not all carry licenses must be honored. Article 4 also includes the highly contentious Privileges and Immunities Clause. There are many interpretations as to the meaning of this clause. A reading of the plain text, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states, seems to leave open many possible interpretations. This clause is frequently cited in interstate conflict, but the courts have primarily held that it limits a state's ability to treat citizens of other states in an overly discriminatory manner, as well as allowing all citizens certain simple freedoms to their life and liberty, as well as their ability to travel between the states. Article 5. Article 5 covers the amendment process to the Constitution. Constitutional amendments may be proposed if passed by 2/3 of either both houses of Congress or by 2/3 of the state legislatures. However, to be ratified, they require 3/4 of both houses of Congress or 3/4 of the state legislatures. Article 6. Most important to Article 6 is the Supremacy Clause of the Constitution. The Supremacy Clause establishes that federal law supersedes state law. This includes the Constitution itself, federal statutes, federal administrative agency regulations, treaties, and federal executive orders. The Supremacy Clause, while asserting federal dominance, is not always enforced. For example, many states have passed laws legalizing marijuana despite federal prohibitions against it. The federal government in previous years has raided marijuana dispensaries, citing the Supremacy Clause, but has more recently ignored them. They still have the authority to conduct these raids and criminalize marijuana use and ownership, but have decided not to do so out of political expediency. Article 7. Article 7 simply states that the proposed Constitution does not take effect until ratified by the legislatures of at least 9 states. The Bill of Rights. The debates over whether to add a Bill of Rights to the Constitution can help us in understanding the Constitution. During the Constitutional Convention in Philadelphia, there were 2 primary political parties, despite the constant warnings the founders gave us about the dangers of political parties, which they called faction. The 2 parties were the Federalists and the Anti-Federalists. The Federalists, among who were the primary drafters and supporters of the Constitution, wanted a stronger federal government. The Anti-Federalists, on the other hand, were very fearful that this new government would replace the tyrannical government we had just left at the great cost of our blood and treasure. The states under Anti-Federalist control refused to ratify this new Constitution unless they attached a Bill of Rights restricting the new federal government. The Federalist argument against the Bill of Rights was that the new Constitution was a restriction on government power, not an expansion. The default position was that the federal government cannot do anything that is not explicitly granted to it in the Constitution. For example, there's nothing in the Constitution that granted Congress the power to pass laws restricting speech, so no First Amendment was necessary. In fact, they believed that by attaching a Bill of Rights, it would confuse the default position that the government can't do most things in the first place. History has proven both sides right. When reading the Bill of Rights, consider again the historical context of the document. These were not simply a group of people sitting down somewhere and waxing poetic about the rights of man. The Bill of Rights all address specific abuses the Americans suffered at the hands of England as subjects of the crown. They wanted to ensure that this new powerful government would be powerless to repeat these abuses. We will close this book with a review of the Bill of Rights, our first 10 amendments. These do not grant rights to the people. They are natural rights the people have. Where these rights come from is a point often up for debate, but the Bill of Rights is ensuring these pre-existing rights cannot be violated by the government. Unlike the remaining amendments, these were ratified alongside the original Constitution. We will also talk about the 14th Amendment due to its importance in modern law and its incorporation of the Bill of Rights to state action. Every good citizen should have these all committed to memory. The First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government with a redress of grievances. The First Amendment covers several different areas. It protects our freedom of religion, or freedom from religion, our freedom of speech, and our freedom of assembly. Each of these needs to be looked at separately. Our freedom of religion was necessary for several reasons. The states were dominated by various religious denominations. Some of them required you be of a certain religion to vote, run for office, or more. If you were not of that area's predominant religion, you may have suffered various forms of discrimination. Further, we had left England, which had its own state-sponsored religion, the Church of England, which was created when Henry VIII was denied an annulment by the Pope in 1534. The First Amendment addresses freedom of religion in the Establishment Clause and the Free Exercise Clause. The Free Exercise Clause simply means you have the freedom to worship or not worship whichever religion you'd like. The Establishment Clause ensures that we do not create a government-sponsored religion, like the Church of England, and that no government action must be made that provides preference to one religion over another. The court created a three-part test to determine if the government has violated the Establishment Clause. First, all government action must have a secular purpose. If the express purpose is to provide preference to one religion over another, or religion to non-religion, then it will be found unconstitutional. Next, the outcome must be secular. If the purpose was secular, but the outcome results in benefit or discrimination against the religion, then it too must be held unconstitutional. And lastly, there must be no excessive government entanglement with religion. The previously mentioned case, McCulloch v. Maryland, about the creation of a national bank, produced case law that impacts the First Amendment's Establishment Clause, even though the case had nothing to do with religion. The state of Maryland sought to tax the national bank. The court denied their ability to do this under the Supremacy Clause, stating that the power to tax is the power to destroy. This has been used as the reasoning behind churches being tax exempt, and it's a good example of how far-reaching case law can be. If a church were made to pay taxes, the government would have the power to increase those taxes such that it would destroy the church. Therefore, it is a violation of the Establishment Clause. Our freedom of speech and assembly exists because of fears that this new government might do what the British did to us. Prior to the Revolution, the British had been known to imprison those who spoke out against Parliament and the King. Patriot news presses were torched. Political assemblies and meetings were broken up by the Crown's authority. The ability to speak out against your government is one of the highest and most important freedoms there are, and every tyrant in history, from George III through Vladimir Putin and Xi Jinping, has been quick to suppress it. The court has permitted various restrictions against our freedom of speech. Early in this book, we talked about the Central Hudson Test, which allowed some restrictions to commercial speech. The court has held that the highest levels of protection are placed upon political and expressive speech. This includes offensive or hate speech. Speech that offends no one needs no protection. However, there is an exception to fighting words. This is speech that is designed to create an immediate violent reaction or panic. The most popular example is that you cannot shout fire in a crowded theater, since it's likely to cause a panic leading to injury. As of this writing, there is a lot of debate over if former President Trump's statements during January 6, 2021 led to the ensuing riots and therefore would not be protected under the First Amendment. A clearer example of this murky doctrine might be as follows. A person is in a protest carrying a sign with racial slurs. This is protected speech. A person targets a single individual, gets inside his personal space, and calls him a racial slur, which leads to an altercation. This might fall under the fighting words doctrine. The most common restrictions to the First Amendment are place and time restrictions. It is permissible to protest loudly on the side of the street. However, if I were to take a bullhorn and continue my protest at 3 a.m. in a residential area, I might be cited for disturbing the peace. The speech itself is protected, but my ability to do it anywhere I want is not. A group of people may peacefully protest the police, but they are not necessarily granted the right to do so in a way that interferes with their ability to do work. It is important to note that the First Amendment and the idea of freedom of speech are two separate concepts. The First Amendment only protects you from punishment by the government. It does not protect you from private penalties. If you post something offensive on social media and are later fired for it, it might be violating the concept of freedom of speech, but it is not violating your First Amendment rights. Your employer has the freedom to associate with who they wish, and if you make your work look bad, you should expect to be disciplined or fired. There's growing argument regarding these place and time restrictions and how they relate to social media. The court previously held that places like malls, despite being privately owned, are to be treated as public property due to their value as meeting areas for large groups of people. Such large areas are the best for the free spread of ideas. Currently, there is a push by some to expand this case law into social media. The court has yet to be presented with such a case, but soon it will surely have to decide if Facebook, Twitter, Instagram, or other social media giants have created public spaces, disallowing them from banning members. The Second Amendment. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Second Amendment is one of the most controversial of all. The Supreme Court held in the case of D.C. v. Heller, 554 U.S. 570, and affirmed in McDonald v. Chicago, 561 U.S. 742, 2010, that this amendment grants individual citizens the right to bear arms. The question as to exactly what arms qualify are constantly under litigation. Like the other amendments, the Second Amendment is in the Bill of Rights because of abuses we suffered at the hands of the British. No tyrannical government wishes to allow those it oppresses to maintain the ability to resist them. This was most evident on April 19, 1775, when the British set off from Boston to seize the guns and powder of patriot militias in the towns of Lexington and Concord. This is what set off the famous midnight riot of Paul Revere to warn the Minutemen who would later be involved in the shot heard round the world, which began the American Revolution. There's much debate about what arms are protected by the Second Amendment. While I will not opine here on what those are, it is worth stating that the Second Amendment exists for two purposes alone, neither of which involve hunting. The Second Amendment exists for the people to be able to take up arms so they can form into groups and defend from a foreign invader, or for the people to take up arms to resist their own government should it become tyrannical, such as what happened to us leading to our revolt from England. That the Second Amendment exists for a military purpose is affirmed by the case U.S. v. Miller, 307 U.S. 174, 1939. In this case, the court upheld the conviction of a bootlegger who was prosecuted for the illegal ownership of a short-barreled shotgun. The court justified this by saying the regulation on this gun did not violate the Second Amendment because the justices believed that short-barreled shotguns served no military purpose. Try telling that to a German soldier in a World War I trench. The Third Amendment. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. The Third Amendment seems the most out of place today and has rarely been litigated in court. But the very fact that this odd amendment is there today further illustrates the fact that these amendments were not added out of thin air, but rather as a direct concern based on violation of our rights at the hands of the British. Following the Boston Tea Party, Parliament passed several laws to punish the colonists. Among these were the Boston Port Act, shutting down Boston Harbor, the colony's largest economic hub, until the tea was paid for. Boston further lost much of its autonomy to Crown control. To enforce this act, several thousand British troops were sent to enforce these laws. Needing some place to put them, Parliament passed the Quartering Act. This law required that soldiers be housed in the private residences of the people. The Third Amendment ensures that this can never be done again during peacetime, and in war only if laws are passed by our own elected representatives. Today, given the existence of our many military bases, we do not see a lot of need to worry about the Third Amendment, but it might well still affect businesses and homes alike. It was never litigated, but following the influx of troops, to include myself, to Washington, D.C. to stand security for the inauguration of President Biden in January of 2021, many of us were placed in hotels, and there was some argument of this being a possible violation of the Third Amendment. Had it been litigated, it is unlikely to have been held as a violation, given that the hotel owners were paid for the rooms and we stayed with their consent. If we stayed with their consent, then who's going to sue? Remember, to bring a lawsuit, you have to have standing. The Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Fourth, Ninth, and 14th Amendments together are sometimes cited when talking about our privacy rights as Americans. The Fourth Amendment protects us from being searched or arrested in the absence of probable cause. It's important to differentiate searches and seizures since they're two different concepts, but in each the standard of probable cause must be met. The Fourth Amendment exists largely due to the excesses of British agents when searching people's homes and other places, particularly as it relates to finding evidence of tax evasion. The rallying cry of "no taxation without representation" was the cause of a substantial amount of tax evasion by the American colonists, from the largest shippers like John Hancock down to your poorest individual not wanting to pay the much-hated taxes on all printed goods that came with the Stamp Act. Tax enforcers would write their own search warrants or eschew them altogether and conduct their searches. The courts have held that any search conducted without a search warrant is considered on its face per se unreasonable. The Fourth Amendment doesn't disallow all searches, it simply disallows searches that are unreasonable. It should come as no surprise that we're back to the word reasonable again. The process of getting a search warrant is like getting an arrest warrant as discussed in the last chapter. The police go to the local judge, present to her the reasons they believe the individual has evidence of criminal activity, and if the judge agrees that there is probable cause, will sign a search warrant. Search warrants must be particular about what they are searching for and where. If the police believe there is a dead body in the backyard, they cannot search inside the house. If they believe there is a dead body in the house, they cannot search in jewelry boxes since a body could not fit in one. The default position is that all warrantless searches are unreasonable, and as we mentioned in the last chapter, the exclusionary rule excludes all evidence from trial that is illegally gathered. There is, of course, an exception to this rule, known as the good faith exception. This does not apply in all jurisdictions, but does in many states and at the federal level. The good faith exception simply means that evidence illegally gathered by the police in good faith, that is, with them making an honest mistake of law, is still admissible despite being illegally gathered. The Fourth Amendment also includes more exceptions than nearly any other area of the Constitution, allowing for warrantless searches. These are Terry searches, the plain view doctrine, searches incident to arrest, searches to prevent the destruction of evidence, consensual searches, searches of probationers, searches of businesses by regulators. A Terry search is when a police officer frisks a suspect. It is called a Terry search because of the case Terry v. Ohio, 392 U.S. 1, 1968. In this case, the Supreme Court created case law which permitted officers who have detained a suspect to pat down or frisk the outside of a suspect's body to search for weapons. This is to ensure the officer's safety during the detention. There are several factors to consider about a Terry search. An officer must have the reasonable suspicion necessary for detention. An officer cannot frisk someone during a consensual contact. And they can only search the outside of the clothes for weapons. If there is no arrest made, lawfully carried weapons must be returned. Under the plain view doctrine, officers do not need to get a search warrant for evidence in plain view. If an officer pulls you over and looks in your window, seeing some blocks of cocaine, they do not need a search warrant to seize those drugs. Some states have used case law to expand the plain view doctrine to the plain smell doctrine or the plain feel doctrine, allowing warrantless searches for evidence that is readily detected through smell or feel during a Terry search. When an individual has been arrested, the officer has gone above reasonable suspicion to probable cause, and now a complete search of the person is permissible. This is for several reasons. from officer safety to the safety of those in jail the suspect is about to mingle with. Evidence gathered will be used against the suspect, and other legal property will become a bailment. The suspect maintains title, but the police have possession while he's in jail. Searches incident to arrest can be somewhat contentious and occasionally run into legal challenges sometimes, like whether the gathering of DNA through a cheek swab for a database is a legal search or not. Courts are split on the matter at this time. Officers do not need a search warrant when there is a high probability of the destruction of evidence. If the police confront a person locked in a bathroom with cocaine, they don't need to go get a search warrant because there's a high likelihood that the suspect is in the process of flushing the evidence down the toilet. Frequently, the police will lack the time, patient, or probable cause necessary to secure a search warrant. Perhaps they've made a consensual contact on a hunch. Or maybe they've developed reasonable suspicion to stop someone and start asking questions. They will likely ask the suspect permission to search them, their home, car, or belongings. You will never consent to a search. Mind you, I'm not saying that you should resist searches. If an officer can search you, he will. But you must not give him permission. It is common for people to give an officer permission to search where they otherwise did not have permission. The reasoning is frequently, well, I didn't want to look guilty. We'll hear this again with the Fifth Amendment. But it is better to have an officer think you are guilty than to grant him permission to search you and helping him know that you are guilty when he finds the evidence. People already convicted of a crime and placed on probation do not have the same Fourth Amendment protections as the rest of us. These Fourth Amendment protections are relaxed as part of their probation agreements, granting their probation officers access to their private areas as well as any common areas they share with others, such as kitchens, living rooms, bathrooms, hallways, etc. Lastly, and most pertinent to the business law student, is that business regulators do not need a search warrant to search those businesses they are lawfully entitled to regulate. If you own a restaurant and the health inspector shows up wanting to check the cleanliness of the kitchen, they do not need a search warrant. But if the police show up and they want to search the back office for drugs, they do need a search warrant. The Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. The Fifth Amendment includes a rather eclectic collection of rights. It addresses grand juries, which we talked about in the previous chapter regarding felonies. It addresses double jeopardy, the right to not be tried a second time once you've been found not guilty, not a hung jury, of a crime. It also covers your right to remain silent and not have to testify against yourself. Lastly, it also includes two major clauses, the Due Process Clause and the Takings Clause. We'll discuss these each individually. The Fifth Amendment exists, like the rights before and after, because of specific abuses the American colonists suffered at the hands of the British. Our nation has a proud tradition of being tax cheats and smugglers, and our founders were no different. John Hancock, most famous for his signature on the Declaration of Independence, was one of the wealthiest men in the colonies and traded in smuggled goods. People were charged with crimes such as smuggling, tax evasion, or battery on British troops and put in front of a jury of their peers, many of whom were smugglers, tax cheats, and people who didn't like British troops. This often resulted in acquittals. Unhappy with this, the British would try defendants repeatedly until a conviction was secured. People were forced to testify against themselves on the witness stand, and private property was often taken at the whim of government agents. Our right to remain silent comes from the words, nor shall be compelled in any criminal case to be a witness against himself in the Fifth Amendment. So not only do you not have to talk to the police, but you also cannot be placed on a witness stand against your will in a criminal case against you. Our right to remain silent is covered as part of your Miranda rights. This comes from a case called Miranda v. Arizona, 384 U.S. 436, 1966. Your Miranda rights must only be read to you after you've been arrested and before any questioning. This is important to understand. Anything you say before arrest, while you've been detained, or during a consensual contact can be used against you, and you needn't have your rights read to you. Anything you say after arrest can be used against you without having your rights read to you if you decide to speak freely and aren't being questioned. Therefore, we do not talk to the police more than absolutely necessary for our safety. The Due Process Clause exists in both the 5th and 14th Amendments. Due process means that the government cannot behave arbitrarily. They must go through a just process according to law prior to engaging in acts that affect our life, liberty, or property. There are two types of due process: substantive due process and procedural due process. Substantive due process means that the law itself must be reasonable and fair. Examples of this include, but are not limited to, laws which are vague or so broad as to criminalize unexpected behaviors. These must be found unconstitutional. Another example is an ex post facto law. This is when you criminalize something today and prosecute someone who did it in the past while it was still legal. Procedural due process means that the procedure itself must be fair. If a person were to be put in prison, have their property seized, or placed in hospital for their protection, then they have the right to be notified and the right to be heard in court. Lastly, we have the Takings Clause. What this means is that the government cannot take your private property except for a public use, and then you must be compensated for that property. This is a power commonly known as eminent domain. Common examples of eminent domain are when a rancher has property taken to allow for the construction of a highway, or when a city takes someone's property to build a school, park, or water treatment plant. In the controversial 2004 case Kelo v. New London, 545 U.S. 469, 2005, the Supreme Court ruled 5-4 to redefine public use as public purpose when they allowed the city of New London, Connecticut to use the power of eminent domain to take homes from citizens to hand over to the pharmaceutical company Pfizer, one of the manufacturers of the COVID vaccine and makers of medications such as Viagra, so they can erect office buildings. The city's justification was that the increase in jobs and tax revenue could assist the city in revitalizing the area, helping everyone. Despite winning the case and the homes being taken, the office buildings never did pop up. The Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The Sixth Amendment grants many constitutional protections to the criminally accused. These rights were all denied to American colonists while under British rule. These rights include the right to a speedy trial, the right to a public trial, the right to a jury of your peers, the right to confront and cross-examine witnesses, the right to compel witnesses to testify, and the right to have an attorney represent you. The right to a speedy public jury trial is important to ensure that the government cannot be arbitrary or secretive about the way a trial is conducted. The people have a right to know and to ensure their government is behaving appropriately. The accused cannot be held in jail for long periods awaiting their trial. If a person is held for years and then found not guilty, then the damage has already been done and people would have been punished by the government even if they are innocent. The ability to confront your accuser or cross-examine witnesses ensures that a suspect cannot be convicted off of anonymous claims that cannot be supported. The Sixth Amendment includes what is called compulsory process. This means that a judge can issue a subpoena ordering that a witness shows up to testify in your case. And you have the right to an attorney every step of the way in a criminal case, to include through your conviction and potential appeals. This is a simple matter of fairness so that prosecutors who are more savvy about legal processes cannot have an unfair advantage over you. We discussed previously whether a public defender can be appointed based on your financial situation. But whether a public defender is appointed or you have a private practice attorney, that attorney can represent you through the criminal process to include appeals and probation. The Seventh Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. The Seventh Amendment ensures the right to jury trials in civil cases where the amount you're suing is more than $20. Note, there is no caveat for inflation. $20 in 1789, when the amendment was drafted, is worth just under 20 times more today. Just in the last year, since the first edition of this text, inflation has already done much to devalue the dollar, so this number is actually likely low at this point. There are many exceptions that have been carved out to this amendment through the common law, and we've seen much of it in action in things we've either experienced or already covered. You'll not be able to have a jury trial in a small claims court, and motions for summary judgment covered in Chapter 2 are just two small examples of this. The primary need for a jury trial in civil cases was to ensure that government cannot determine how to dispose of your property by favoritism. If you had a bench trial where the judge was inclined to one party, either by nepotism or corruption, that judge might order a winner in a civil suit that is not based on law. A jury of your peers increases the likelihood of a just outcome. The Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The Eighth Amendment protects us from cruel and unusual punishments and excessive bail. It was not uncommon for American colonists facing charges to be held without bail for long periods prior to their trial. A person held without bail, or with a bond amount so large it couldn't be met, are in effect the same thing. Also, a person convicted of a crime at the time was sometimes subject to very creative and severe punishments. We've discussed the factors a court must consider when setting bail in the last chapter. Bail is used as a security to ensure the defendant returns to see his case through to its conclusion. If he does, the money is returned or advanced to pay fines imposed by the judge if convicted. This amount needs to be high enough that the defendant will be harmed if they run away, but it needs to be low enough that it's possible to be met. The Eighth Amendment's other purpose is simply to require that, if convicted, your punishment fits the crime. If you're fined for speeding, your ticket cannot be $100,000. If you're convicted of stealing a candy bar at the store, you cannot be subject to execution. The term cruel and unusual is a fairly ambiguous term, and at the state level, a good amount of research into case law may be necessary if a judge attempts to impose a punishment you feel is unusual. The term is also ambiguous enough that states are split on whether things like the death penalty or prolonged solitary confinement qualify as violations of the Eighth Amendment. The Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The Ninth Amendment is one of the more controversial amendments due to its lack of clear and concrete language. It has been interpreted very broadly, and everyone has an opinion on what does or does not qualify as a right protected by the Ninth Amendment. As a concept, this isn't entirely removed from what the drafters wanted. As has been mentioned several times now, the Bill of Rights wasn't a mere brainstorming of human rights. It was a listing of rights the Americans believed we had, which had already been violated by the British, and they wanted to ensure such violations weren't repeated by this new powerful central government that replaced the weak one in the Articles of Confederation. The concern necessitating the Ninth Amendment was like the concern the Federalists had in opposing the addition of the Bill of Rights as a whole. If they were to specifically make a list called the Bill of Rights, then it may cause some confusion in the future that this list was all the rights the people had, and therefore anything beyond that would not be protected. The founders were aware that they had not outlined all the rights of man, and that future generations and future problems might arise which caused unforeseen rights to be called into question. In short, the Ninth Amendment states that we have more rights than just those listed in the Bill of Rights. However, simply reading the amendment hardly helps us determine what those rights are. People have argued that the right to travel, the right to get an abortion, the right to work, and many more qualify as rights under the Ninth Amendment. They might be right, but it's difficult to say for sure through a plain reading of the amendment. Some scholars argue that the Ninth Amendment does not in fact grant us additional rights, but rather that it's simply repeating the proper reading of the Constitution, that the default position is that the government cannot do anything and must find their powers specifically in the Constitution. For them to engage in any acts at all, they must be able to point in the Constitution to where they can do something. Others argue that it affects state powers. There are many jurists and legal historical scholars who disagree about the proper interpretation of this amendment. The 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively or to the people. The 10th Amendment is what people are talking about when they talk about states' rights. The Articles of Confederation were notoriously weak. They gave all the power to the states and precious little power to the national government. The fear, especially by the Anti-Federalists, was that instead of simply granting this new central government more power to fix some of the problems in the Articles of Confederation, the Constitution would make the federal government the primary power that takes over governing the daily lives of people. As we know today, this fear is not entirely unfounded, given the fact that our national government has regulated everything down to the age a person is allowed to use a vape pen or what kind of light bulbs you're allowed to buy at the store. To satisfy the Anti-Federalists, the 10th Amendment was placed in the Bill of Rights to guarantee that the police powers rested foremost with the states. Police powers have nothing to do with the cops, but rather with the ability to pass laws regulating the day-to-day lives and general welfare of the people. The reason they wish this power to stay with the states is because that is where you are best represented. Consider Anti-Federalist George Mason's concerns about the House of Representatives when arguing against the Constitution. Quote, "The utmost that we can expect, and perhaps that is too much, is that the present number shall be continued to us. The number of representatives shall not exceed 1 for every 30,000. Now will not this be complied with, although the present number should never be increased? Nay, although it should be decreased? Suppose Congress should say that we should have 1 for every 200,000. Will not the Constitution be complied with? For 1 for every 200,000 does not exceed 1 for every 30,000. There is a want of proportion that ought to be strictly guarded against." End quote. The House of Representatives is supposed to be the people's house. Mason is saying here that the most democratic institution we have in our government is the House of Representatives. But it is impossible for one representative to speak for 30,000 people. Today, that number stands at 1 representative per 767,000 citizens. Now consider New York. Their House of Representatives, called their Assembly, consists of 1 state representative per 133,000 citizens. Washington has 1 representative per 80,000 citizens. This number is still problematic for someone like George Mason, but it's clearly more democratic and representative of the people than the National House of Representatives. The 10th Amendment was added to make clear the way a federalist system is supposed to work. The federal government and the state governments had their own spheres of influence. Many legal and historical scholars have argued that the 10th Amendment has lost much of its meaning and influence as the federal government has gained and continues to gain power. They've done so through the court's interpretations of things like the commerce and necessary and proper clauses. In actual practice, states' rights, like most provisions of the Constitution, are only argued for when politically expedient. If a Republican-controlled Congress passes a sweeping law, Democrats argue that it violates states' rights. If a Democrat-controlled Congress passes a sweeping law, Republicans argue that it violates states' rights. A plain reading of the 10th Amendment is again a recitation of the proper manner of interpreting the Constitution. The default position is that the federal government can do nothing unless the Constitution explicitly says it can. All other powers remain with the states or with the people themselves. The 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The 14th Amendment is not a part of the Bill of Rights, but it warrants special mention in this chapter for several reasons. This amendment is large, and the section of most import is Section 1. It grants citizenship to anyone born in the U.S. It includes the highly debated Privileges and Immunities Clause, another due process clause, and the Equal Protection Clause. Here we will address incorporation of the Bill of Rights through the Due Process Clause, as well as talk about the Equal Protection Clause. In the Fifth Amendment, we discussed the Due Process Clause and how it includes both substantive due process and procedural due process. The court has used the Due Process Clause of the 14th Amendment to incorporate the Bill of Rights and apply them to the states. The initial understanding of the Constitution was that it bound the federal government, but not the states. In fact, we saw this shortly into our young nation's history during the presidency of our second president, John Adams. With possible war with France looming, Congress had passed what were called the Alien and Sedition Acts. These laws criminalized speaking out against the government, and many newspapers criticizing the government were shut down and reporters imprisoned. These acts were criticized by many who still sought to have people prosecuted under similar acts at the state level. Today, through the 14th Amendment, state laws violating the First Amendment are also unconstitutional. The courts have interpreted the Bill of Rights one at a time, and today only the Fifth Amendment's grand jury requirement, as well as the Third and Seventh Amendments, have not been incorporated to apply to the states, likely due to them not being litigated before the Supreme Court recently. When talking about the Bill of Rights being applied to the states, it's important to understand that the Constitution provides a basement, not a ceiling, when it comes to your rights. States can provide greater protection than the Bill of Rights, but they cannot provide less protection. Lastly, we have the Equal Protection Clause. The Equal Protection Clause guarantees every American citizen be treated equally before the law. Placed into historical context, the 13th Amendment outlawed slavery. The 14th Amendment was ratified alongside it. So the 13th Amendment freed the slaves, and the 14th Amendment ensured that freed slaves would be treated the same as everyone else under the law. This obviously did not happen overnight in practice, but that is what the law itself stated. Like with the other amendments to the Bill of Rights, this right has expanded over time to keep up with the times. Where the Equal Protection Clause initially addressed race, it has come to encompass gender, religion, sexual orientation, and other immutable characteristics.